Hello and welcome to this week's BizSmart Lunch and Learn webinar. Our weekly webinars are aimed to provide advice and share knowledge amongst business owners on key business topics and specialist areas. This is part of our service to our Smart Room members. If you're not already a member or a BizSmart client and would like to access our archive of webinars, then please visit our website biz-smart.co.uk and go to the Smart Room page. Our host joining me today is BizSmart member and core advisor Steve Parker from International Company Development. But before we start the webinar, can I ask you all to use the question mark function on your screen to post any questions that you may have for Steve, and he will do his best to answer them all at the end of the session. Thank you, Steve. Over to you.
Thank you, Caroline. Good afternoon, everybody, or if you're listening to this on catch-up, good morning, wherever you are. We've got a really interesting but really quite difficult subject to mix in during today's webinar. It's probably going to also need a second one to get into some more detail, so forgive us if we don't go into a huge amount of detail on what are two wide subjects, but there's been a lot of talk recently about intellectual property and protecting your brand and your products and your services. But to me, in my world, there's an indelible link between protecting your IP and building into the way you do your sales, your marketing, and your product development to help you protect it and not just rely on the legal system. So the comments and the experiences are based on having, as you'll see, invented and been involved in lots of new product development over the years, and typically in respect to the problems you face when you come to sell them globally. We're going to use some real-time examples just to try and open your mind and your thoughts into how you can apply those thought processes to your own business, to your own product development, and also even if you don't have any product developments coming up, how you can do your own audit, if you like, of the strength of any protection that you may have already received. One of the biggest frustrations I've had in business over the years is when you put all the hard work and creativity into setting up your company, establishing the brand, and then somebody copies it. Or you come up with a brand new product and it's your hope and your dream and your aspiration, and it's the way of making you millions. And then somebody with less moral standards or skills, or just because they think they can pick on you, then goes and copies it and dilutes it. You hear it a lot typically from Far East markets and things like that. So we're going to link the two in that you're not just going to rely on the legal process, which could almost be a subject in itself and might be the subject of a future webinar, but we're going to link with how you can take your own actions and your own ideas to give you a stronger way of putting people off copying it and making it so damn difficult to copy that you'll establish brand loyalty and brand support, and you'll have people policing it for you. So it's a link, possibly an unusual one, between your intellectual property and your legal protection, and what strategically with BizSmart and others you would call your unique selling points, how you sell, market it better, and how you do it. So here we are. Let's start at the very beginning. A bit more background, because I'd forgotten I'd got this slide in. You've seen some of these before. Done extensive work in lots of countries, 30 years successfully exporting to markets worldwide, where we faced every kind of competition there ever is, and we still do. I still export pretty much every day of the week. Set up manufacturing operations and global operations in some countries, where again we've had to take into account the local and national regulations in terms of brand and IP. They vary considerably to country. And one of the biggest thrills in my business career has been working with inventors for new products, where something is started by on a piece of paper, developed into making it into somebody's shed, which is then developed into making it into a factory in a company. And we've had all of that fun of seeing it grow, and indeed to this day one of the biggest thrills has been with a couple in their 60s who I helped to develop a product with, who now go on a cruise on the QE2 every year and still send me a postcard because they're from an era when you did. And that was all done on the basis of deciding to do a little bit of IP protection along the way, fighting hard with their own personalities and their own brains and their own selling points, and ultimately getting it to a level where a large company came along and bought their company and their product and took on all of the IP issues themselves. And they made a few £100,000 for it, which is presumably why they still send me a postcard. But maybe if we'd have sold the company for more, they could have invited me along as well. But never mind the details. I also run a company called Starbridge Glass International, where pretty much everything we do is open to copy. Pretty much everything we do is new and different. So I have the consideration as to whether I want to do the legal process to help me to protect it, or whether we just try and protect it through the relationships that we develop along the way. And the smart aspect that you've seen on the webinar on that page is that I advise nationally the Federation of Small Businesses. I'm on their national IP board, which means they think I understand it a little bit, and advise people, including the Black Country Local Enterprise Partnership, on considerations on that IP and international trade. The rest of it you can see on the slide. We'll move on to the bits you're really interested in. So if IP, intellectual property, has some confusing meanings, let's tell you what the three basics of them are. You've probably heard of patents or patents. I've had three definitions, three pronunciations of that with three different people I've spoken to. Call it what you will, it's spelled P-A-T-E-N-T. The precise definition of that is it's something that can be granted to someone who has created something that is useful. They've invented something, an invention, a new product that it's, thank you. So that they've invented that's new or different. It can be a product, it can be whatever you like. And the legal protection for that, taking out a patent or a patent, whichever you prefer, is essentially meant to stop others making, using and selling your invention, or arguably to put them off making, selling or using your invention. The other one that you would have heard of is a trademark, and that's meant to distinguish the goods and services of one company or one trader from those of another. People think this is brand protection, and to some extent it can be, and therefore it includes more than just protecting your logo. The definition in legal terms of a brand is a promise of an experience, which is relevant to this discussion as well, because the promise of an experience means that you're not just selling a product or a service, but you're putting some personality behind it, you're putting some support behind it, and you're helping those people that you're selling it to sell it as well. And the third main one is a design for appearance, which is you and I would typically know as a registered designer, though it can cover something called an unregistered design as well, which is in its simplest terms describing the appearance or the look of the product that you're doing it. And this, as you've seen, is aimed at preventing other manufacturers from taking your idea and then making it themselves. That looks a good idea. That company's making lots of it. I can't be bothered to work out, I can't be bothered to buy it off them. I want to make the money myself. And then you do it. And you'll have seen lots of examples of fake and imitations coming in from all sorts of countries where they go and do it. Now, we're going to touch on some of these in a little bit more detail, but if you, there's a couple of websites on there which will give you a greater thing. I'd rather you didn't look at it in the next 20 minutes, otherwise I'll be talking to myself. But if you look at the Intellectual Property Office, which is the government one, www.ipo.gov.uk, and ACID, which is the Anti-Copying in Design organisation, www.acid.uk.com. Lots of more detail on that, but this is so if we're thinking in these discussions, this conversation about patent, trademark and registered design, then you'll get a feel for it. One of the first things you can do if you then look at those sites and you get bamboozled by it all is where on earth do I start? Because you're a small company, you don't have a lot of time. It should be part of your strategic thinking from the start, and then it's always in your head as to about how you do it. There is a valuing your IP simple exercise which I'd recommend that you do. And if you're a smaller company, just give some serious strategic thought into identifying the products and the services that are absolutely key to your business, so that even if you don't want to protect all of them, the ones that are giving you 80 or 90% of your turnover or are most valuable to you financially and emotionally, then look at those. Really, if you've done some BizSmart strategy sessions, it will have highlighted the real market advantages, the stronger selling points that these give you, so that then you can think about protecting them as a kind of insurance. And you can work through that part of it. You can come up with some values both financially and emotionally. But then the link to the next part of this is that you very, very, very seriously consider whether you're just going to pay money to register those and to develop them to become, to, if you like, formalize an asset in your business, or whether you're going to use them because if any young whippersnapper does come along and copies your product and starts to sell it, whether you'll have the mental and the financial capacity to protect them. Whether you want to just send threatening letters and nasty letters to them, or whether you're going to invoke the legal process. Because if you're going to spend thousands and thousands and thousands of pounds on registering your patent and your trademark and anything else, if you're not going to actually then enforce it to the level that you want to, then maybe, just maybe, it could be worth spending your money elsewhere. So the reality is, you won't often be told this, the reality is that the current IP protection in the UK and globally isn't airtight. It's not always practical for small and micro businesses. If you choose to register a patent, if you choose to register some of the other things, you have to get it approved in many cases, for it to be entirely meaningful, have to put in so much detail that it's actually contradictory and that you're giving away some of your ideas and your designs to people. And that is free and open in the public domain, and you're actually causing yourself, arguably controversially to any legal people listening, causing more problems than you're actually solving, because there are companies that I know in the particularly in the Far East and other parts of the world who will go onto the sites where you register them and get ideas and then try to make them cheaper with and do imitations. That's where they get their ideas from, rather than you who've thought of them yourself and you put your heart and soul into developing it. So this is just a cautionary note that you're doing it. And if you are there thinking that, well, this guy's not talking sense, there can't be such a system. There was a recent landmark case involving a ride-on kids luggage company called Chunky. I believe you may have seen them on Dragon's Den many years ago, a while ago. They invested it, they protected it, and they, as you can see from the slide, invested a huge amount, spending thousands and potentially lots of thousands of pounds, putting together all the IP protections they wanted, including the trademark registration. And they did this, as you can see, in 51 countries. They took out 65 EU design registrations and 8 patents. And then somebody in the Far East tried to copy it, and they took them to court and they lost. And there are lots of repercussions in that, because all of a sudden people around the world are checking whether their legal protection is as big as it was. I put a balloon on there, they took out all of those. They thought they were strategically sound. They could justify their investment to themselves, and they went off and sold to the rest of the world, which I would always encourage you to do. And they were floating around in their little balloon until somebody tried to test it out, and they lost. And they're still fighting it, and it's really damaged it. So there's the justification for saying. And the discussions at national and international level include the fact that the realization was that the legislation in all of the parts of the world, and different countries have their own different legislation. Europe has some Europe-wide ones as well as individual country ones, without getting into European debate, and they're all interpreted in different ways, and that the legislation itself was geared around large companies who had large legal departments and who could afford it. And now the world is faced with that 90% of the companies are small and micro businesses, and they don't have legal departments and they can't afford to do it, and they need the surety that if you and I invest all those money in it, that it's actually going to be meaningful. Otherwise, well, let's think of another way of doing it. So here's the next bit then. You know that to register one, you've got to pay lots of money, you've got to come up with your design, you've got to put it in your public domain, and crikey, isn't that hard work? That's all money and time and expertise that you could make about selling it. So why don't we, with our small powers, think about making our products and our designs and the way we sell it and the people we sell it to so darn difficult to copy that it'll either put people off in the first place, or that it'll make it really tricky for them to make it, and then they'll pick on some of the other guys. So my suggestion is, strategically, while you're thinking about your IP, you also strategically think about your design and how you sell it and how you market it. Seems like a good idea. Most of us have to do that every day. So here's a way of doing it. I run a glass company called Starbridge Glass International. We're open to copy every time. We come up with new designs most days of the week, most weeks of the year, and when we put them out into the public domain, we're open to copy. Because we're clever monkeys, and we do keep coming up with new feature pieces, we do it. Our problem is that irrespective of any legalities, we haven't got the time and the money to invest in every one. Everyone would need a variation. And then we also know that when we're working on some of these large commercial buildings that you see around the world, some of which we compete for, then not aligned to any legal process, but when the project goes out to tender, most countries insist on a wonderful phrase called "and equal or other approved." So I can put a load of specification work in, we could have come up with the design, we could have convinced some people, but it then still has to go out to tender so that one company doesn't get the monopoly. So here's an example that we'll progress with. Let's imagine for now that I've had detailed discussions with a client and an interior designer and some other people about a design and a concept, and we do it. We then bring it back, and we then decide. They've decided what they think they want, we've given them some pictures, we've given them some tiles, and they say that they're going to support us if we do it. They want to specify us, they want to work with us, but we have to remember that we need their support. So I then bring it back, and we sit round and we work out how we're going to create those pieces, not only so they do they're functional, they add the value to the building, they add the wow factor to the building, but that we get the best chance of getting the order. The emphasis is on that we get the order, because we're not in the habit of putting a whole load of work and creativity and mental and financial support into it, so we don't. So here's one that we made earlier. And we came up with some designs, and I can't show you the finished pieces. Well, I'll show you the finished pieces afterwards. So when we're looking at the way we're going to design it, we know what the client wants it to look like. We know what atmosphere it's supposed to create. We know where it's going to go. We know all those other details. So we then start to consider, in the privacy of our locked doors and our own offices, not just what it's going to look like, but how we can build things in which will make it so damn difficult to create those effects and very, very, very difficult to copy. The left-hand side is a sketch which we tweaked around with. We don't have the time for me to point out some of the difficulties within it, and actually if I did, I'd be giving away my IP, so I'm not going to tell you anyway. And then there are various ways, as you can imagine, of making those shapes, but we decided to make those by a different process. We did it to design it by a different process to, in theory, create the best effect and the biggest wow factor. But it was a consideration all along that some of our main competitors had great difficulty in using that kind of process. To do the prototype, to see if we could actually do it, it breaks it down into the image on the right where we created molds and we created a version of doing it. So then we made them, and there's two of the examples that we did earlier. They were part of a range of features which went in the corporate boardrooms of a PLC that sells worldwide. And we also wanted that when they went out, we wanted to give the client and the interior designer and our partners lots of reasons for rejecting the other two quotes, the other two offers, the people who didn't want to use it, the people who took it to India or the Czech Republic or in China to try and get it made at a fraction of the price. And instead of being creative and trying to sell it against us with fantastically better designs, they tried to sell it on price and cheaper. So imagine the cost to us of legally and financially protecting that, protecting our brand for it, protecting our design for it, and then having the mental and the financial capacity that when those people came along and copied it, we wouldn't be able to do it. The margin would have gone out of it, the time and the effort would have gone out of it. So while you're thinking about those, look at those lovely images, look at those pieces. It doesn't matter to me whether you like them or whether you don't, but just look at the amount of detail on that. We also, for every piece that we make, subtly put identification marks on it. I'd like to suggest you can do that with almost any product you like. And also we personalize it. People are buying for some people. They want to protect us. They want a reason to use us. They've already mentally worked out how much it's going to cost, so it isn't a surprise. And so we build it into the selling process. When we're selling it and marketing it, we point out features of the design. We point out all sorts of areas. You can do that with yours, which means they're not buying a commodity and they're buying some products and a personality and a great British company to do it. Now, you've only got so much time and money in the world, so my thought and what I'm opening your minds to do here is that you put a lot of that effort into your designs, into how you sell and market it, how you develop those relationships, so that whether it goes to somebody in the black country or whether it goes to somebody in Qatar, it doesn't matter. My argument is that if you were never actually going to legally enforce it, then why not put the effort into that discreet design? The other reason that we sign and put discrete marks on as part of protecting your IP is that if somebody does copy it and they send it out into the market and they have a problem with it, if you then at that stage and they're trying to get a refund or a discount, or they're trying to damage your IP by saying you made an inferior product, then by asking them closely or from a distance to go and look somewhere to find a mark, to give an identification, you can tell whether it's actually yours. And we did a project not involving these pieces where we only got 3/4 of the project in the first place. An Indian company made 25% of it, and then the client complained why one was a different colour to another. And without even visiting the site or knowing who made it, we could get them to have a look at it and find out that actually somebody had infringed our IP and they tried to copy the design to save some money. And the original pieces from the Indian company were taken out, and then we got the chance to recover the 25%. So there are commercial ways of doing it. Bigger subject. So in the last few minutes, how can I do it how can you do it when you're thinking about your business? And let's just work through a few of those. And then I've got another example of the way somebody's done it with a completely different product from a BizSmart client at the end of it. So your IP considerations when you do your IP audit, when you're thinking about it, when you're building it into planning, when you're building it into your new product development, new strategy, be conscious of the possibility of someone copying it. It can be easier for some people to copy it than innovate. So just get used to the fact that you may not always be able to protect it. Don't let it come as a surprise when you see it out in the market. And it's the better you get, the more open you are to it, the more people will discover it, the more people will throw money at it and try and do it better than you can. An obvious one is always control your own tooling and build identification marks in it. I don't care whether you're getting your tooling made overseas, build in some discrete marks so when your product comes out, there's an identification mark. Maybe it could be a patent applied for, maybe it could be a symbol. It just means that those people who are smiling nicely, if they come to reproduce that tooling, can't build exactly the same thing as you are, so you're protecting your IP. Never ever lose control of your own tooling because you're just giving a free rein for somebody else to make it. Third one is slightly more controversial. Even if there are grants and financial help to ask you to publicly tender, just be a little bit careful. There is a grant available around here lately where it says that for a grant of more than 25k, you have to put the information in the public domain. You have to be very, very careful that if you put it in the public domain, you don't tell some of your competitors that you're developing this great new product to go into this great new sector so that they can suddenly start to do it themselves. So be fairly discreet. Sell, design your product, get the, you can use NDAs, non-disclosure agreements, but make sure you want to enforce them if you can. One further down, lots of people have been tempted to use overseas manufacturers in places such as China. It's where Chinese flu came from. Yeah, just be a little bit careful. There are lots of inspection agencies that you can now use so that when they're making the product for you, you can get inspection agencies to go in to check the products, to check the quality, to check the specification, and also to counter another trick which some of the people do, which is to, whilst being your best friend and loving to make it for you, accidentally put in their own manufacturers' literature and identification marks in your packaging somewhere so that they can say along the lines of, I thought you might like to know that these aren't made in England, we make them for you and we can make them without their markup. So inspection agencies, I've worked with some who for the sake of 1% of the product cost will do a 95% inspection. It acts as a deterrent, it protects your IP, and it's a whole lot cheaper than doing patents and trademark protection. Personalize it, make it you, make it your own, prevent impersonators, and do it like that and find the element of it, and include an element of fun in your product and service that people want to buy you. Can be done for some others. There's a BizSmart client, A to Z Rainbow Drugs, do fantastic drugs. One of the ways that helps them to protect it, we have developed a range of characters called the Truglins. It personalises it, it makes it fun. We can do endless variations on the faces. There are currently 5, but there will be more. It helps to differentiate between somebody who might be mass producing a product and saying you don't need to buy it from England, you can buy it from elsewhere. So that is not just a fun thing to do, it's a way of protecting an IP, and it's a product differentiator and a market sector. Finally, too big a subject to cover in one. Hopefully I've made you think about your USPs and your IPs and all that other. If you've got products, ideas, thoughts, the call to action, which I've used before, contact me, make me a cup of tea, we'll do a phone call, we'll meet in your office, we'll have a chat about not only how you can sell it globally, sell it better in the UK, but how you can protect your IP at the same time.
Great, thank you very much, Steve. We have a number of questions coming through for you to answer. The first one is from Sarah, and she asks, are there different IP regulations in different countries?
Yes, there are, and that's why you probably need the help of some of the ones, some of the organisations will repeat the websites for. You're right. Some of the regulations would mean, for example, that you might own the domain in your country, even if it's only on your website, and so you need to check out whether somebody's legally required, whether somebody's legally able to register it, even without your help. So it's best to look at it if you have particular problems with a country, to make sure that if you do a UK one, how valid it is, and the Intellectual Property Office and people like myself will know where to check that out to see how valid it is. So it's a really valid question.
Okay, great. Next question is from Pauline. Are there any government bodies to help protect our designs?
There are. We mentioned before the Intellectual Property Office, which is the www.ipo.gov.uk. They're a good place to start. Rather ironically, and I think it might tell you something in the small print, they do some courses, they do lots of free advice. The bit I really liked in my Black Country humour was that they do a crash course in IP stuff, which is a bit scary. So they do some, and a number of smaller designers and some of my glass designers use ACID, which is the anti-copying in design. A reminder that if you go to www.acid.uk.com, there's quite a bit of free information, but they also do membership, which gives you access to it. So for without being an advert for them, if your turnover is under 50,000 quid, it might cost you 198, 200 pounds in your first year to get access to it if you want to try and assess the level of risk that you're putting yourself to at the same time. So between ACID and IPO, I've been on one or two IPO things, courses to get a greater feel for it, to upskill and things like that. Have a look at that, and then talk it through with me or with one of the BizSmart gang to realistically assess, because sometimes it's what you can afford to protect, and sometimes it's how you respond to people the first time that they actually infringe. Okay. Okay,
thank you. Your next question is from Stacey. I make green and innovative insecticides which combine several quite well-known natural ingredients, but in a new way. Two have recently been tested by University of Bristol and are not yet out in the public. Can I establish these as IP ideas?
You probably can. There is a way of checking whether something similar has already been done. There's a register of patents and designs which you can get checked out so that you can see whether somebody's already got it, somebody's already using it, and then if you decide you want to protect it, whether you want to protect the recipe, whether you want to protect the design, whether you want to protect your company, and then it makes it a commercial and a decision. So yeah, if you want to contact me confidentially, we'll work through that with you just to see how you can do it. And then, as we've said with this, hopefully some of this discussion has been useful, because you might decide that you're going to protect some of it by the way you sell it and market it, and ultimately get paid for it. You might not want to sell it to everybody.
Okay, great, thank you. Another question from Simon. What makes a good USP?
A good USP is not just the product the product or service that sells you the most. It has an element of your own personality and your own company behind it, so that it's not just a commodity. It's, I want to keep buying from these people, and it's the old saying, it's something where you sell something, where you sell products and services that don't come back to people who do, because nobody's better at being new than you are, and hopefully nobody can make your product and your product design and the flexibility of your product design as well as you can.
Okay. Lovely. Thank you. Thank you, Steve, for hosting today's webinar. I will be sending out a copy of Steve's presentation and his contact details out to you all very shortly. So please do email him any further questions that you may have direct. Just before we close, this is a quick reminder. This webinar is part of our service to our Smart Room members. If you're not already a member or a BizSmart client and would like to access our archive of webinars, then please do visit our website, biz-smart.co.uk, and go to the Smart Room page. We hope you enjoy the rest of your day and you can join us again soon. Thank you very much for listening.